We'll be discussing today the further analysis of the arbitration agreement in this lecture. I'll be talking about different aspects relating to the arbitration agreement specifically. The arbitration agreement, as we know, confers the mandate on the arbitral tribunal to assume jurisdiction over the dispute that has been referred to the arbitral tribunal in light of the arbitration agreement, or a submission agreement executed subsequent to the dispute arising between the parties. The tribunal generally has the jurisdiction to decide any and all disputes within its ambit. The arbitral tribunal is required not to exceed its ambit, the mandate given to it. Otherwise, the parties risk the award being refused for recognition and enforcement. Article 5 subsection 1 subsection C of the New York Convention provides that recognition and enforcement may be refused, and the UN Model Law on Arbitration provides similar provision. The three main claims that generally fall within the scope of arbitration agreement include contractual claims, as that includes anything incidental to the contract, such as issues of quantum, tortious liability claims, as well as statutory claims, which increasingly are being referred to arbitration, such as antitrust or securities disputes. Now, it is necessary to determine whether a specific claim or defense has sufficient connection with the contract that can be arbitrated, over which the tribunal can exercise its jurisdiction. For this, the arbitral tribunal and the judge would examine the precise wording of the arbitration agreement and the contract, which requires that a mandatory obligatory language is used in the arbitration agreement. The choice of words employed by the parties should be sufficient to fulfill their intention. Because the parties want there to be a duty imposed on each other to arbitrate in a mandatory manner and not merely be expressed as a mere right to arbitration. Typically, in international commercial contracts, the parties seek to resolve all issues and disputes arising out of the contract, the main contract, commercial contract, through arbitration. Therefore, it is important to draft it in an inclusionary and broad manner instead of referring the arbitration to some specific disputes or claims and leaving others to the jurisdiction of the national courts, which risks splitting up claims that may be connected and may defeat the whole purpose of engaging in arbitration. The attitude of national courts towards international arbitration is increasingly positive and sportive. National courts generally treat international commercial disputes to be highly appropriate for arbitration, and they seek to give full effect to the arbitration agreement wherever possible, instead of interpreting it or construing it in restrictive manner. This is evident from English Court of Appeal referring to the presumption of one-stop arbitration in the interpretation of the arbitration agreement. Similarly, the Swiss approach is that any reference to disputes related to the agreement would go beyond the main contract as well. It will also apply to ancillary or connected contractual claims unless those contracts contain some other dispute resolution method. Now the question arises, how to bring a dispute within the ambit of arbitration agreement. Now for this, simply broad language is always preferable when drafting arbitration agreements, and we will see shortly a standard clause provided by practical law. Words such as claim, differences, disputes have been held by English courts as containing wide jurisdiction for the arbitral tribunal to arbitrate the matter. In the US, the words such as claims or controversies similarly have wide meaning. Linking words such as in connection with, in relation to, in respect of, with regard to, under, rising out of, etc. Can be very important. English court in Fiona Trust then sought to draw a line between what words are sufficient to refer to arbitration, and it stated that a line of some sort is to be drawn and a fresh start made at any date for cases arising in an international commercial contracts. Ordinary businessmen would be surprised at the nice distinctions drawn in the cases and the time taken up by argument in debating whether a particular dispute or case falls within the one set of words or another very similar set of words. If any submission did not want to exclude, if any submission did want to exclude disputes about the validity of a contract, it would be comparatively simple to say so. The conduct in referring to arbitration is also important. Of the parties, the jurisdiction of the tribunal may extend to claims beyond what is contained or referred to in the arbitration clause, where parties impliedly do so. For instance, they may submit a claim in tort not contained in the arbitration agreement, and if they do not make any reservation as to the jurisdiction of the arbitral tribunal, that claim would also be arbitrable. Now, the another thing is to draft the arbitration agreement in wide terms and include all the necessary elements, which we'll also discuss in the next slide. But here, the unsuitable model approach is to include following clause: any dispute, controversy, or claim arising out of or relating to this contract, or the breach, termination, or invalidity thereof should be admissible to arbitration. It is preferable to use standard clauses provided by institutional arbitrations as a source of soft law for international arbitration, such as by Singapore International Arbitration Center, ICC, LCIA, UNCITRAL. It's also recommended to use institutional rules. For instance, a clause: resolution of disputes, arbitration Paris, while not invalid, is not recommended, but it would still work in favor of arbitration and would be valid submission clause. Other things that must be specified include language, legal place or seat of arbitration, number of arbitrators, etc. Now coming to the key elements of an arbitration agreement. Firstly, there must be valid arbitration agreement, and it also depends a lot on the law of the seat, what the requirements are, but generally they are very harmonized. It must also be made clear, as it is in the model clauses, that the parties intend that any and all disputes between them shall be finally resolved by arbitration. The examples of defective clauses in which the intention was not made clear would be discussed subsequently. Another important thing is the number of arbitrators that should also be specified, and it is recommended that uneven number of arbitrators should be appointed. A choice can be made between one or three. Generally, three arbitrators are sufficient to resolve any dispute of complexity. It is an outdated approach to appoint only two arbitrators with an umpire or referee to adjudicate between them if they cannot agree. But this may be appropriate in case of arbitrations within a defined trade or commodity association. But today in international arbitration, it is unheard of. The constitution of the arbitral tribunal would be discussed in next part when discussing the arbitral tribunals. Another is whether to choose ad hoc or institutional arbitration. This decision should not be left for a later stage, and usually the timing for this is not always ideal, because when the parties are embroiled in a heated or contested dispute, they may not be talking to each other and may not have the propensity to amicably decide on these issues. So the good sense is that the agreement to arbitrate must be negotiated, concluded when the main contract is executed. Because, as one commentator said, the primary objective in inserting an arbitration clause in a contract is to ensure that when the time comes, that is, when a dispute parts the parties, neither one will be able to escape the arbitration. Fifthly, filling vacancies in the arbitrable tribunal, there should be provision for that as well. It may become necessary to replace an arbitrator because of the appointment being successfully challenged, such as for failure to disclose a conflict of interest, or because of death or resignation. And the rules of established arbitral institutions often contain comprehensive procedure to cover such eventualities. Another is deciding, very important issue is to decide the place of arbitration, the legal seat of arbitration that provides the courts of that jurisdiction with curial jurisdiction or residual jurisdiction to fill in gaps where the transnational law of arbitration does not help, where the institutional rules of arbitration may be inadequate, and as well as for supervision of the arbitral proceedings. Now, it is generally the law of that place that governs the arbitral proceedings and any challenge to the ultimate award. It is therefore highly advisable for the parties themselves to choose a suitable place of arbitration instead of leaving that choice to someone else. They should locate their arbitration in a state which laws are most suited for and adapted to the needs of modern international commercial arbitrations, which are party to the NYC. They should also take into account practical matters such as distance, availability of advocate, hearing, backup services, and to help with the evidential process. Another thing is governing law to arbitration, to the arbitration agreement, which may be different than the governing law of the main substantive contract from which the dispute has arisen. The parties' the contract should contain a choice of law clause and should also making an express provision for the governing law of the arbitration agreement. And where the parties do not expressly agree on governing law for the arbitration agreement, it is generally the choice of law of the main contract that can be taken as a strong indication that they wish to adopt the same law for the arbitration agreement. But where the contract does not contain a choice of law clause for the main contract, or where the arbitration agreement was not part of that contract, courts often turn to the party's choice of seat to determine the law governing the arbitration agreement, and they also determine which law has the closest and most real connection to the arbitration agreement. Now, there have been a lot of developments recently in this regard. The position of closest and most real connection was one taken previously in Sulemarga case in England and Wales. In the recent Inca case, the Supreme Court held, and that there are good reasons of legal certainty, coherence, consistency, and to avoid artificiality and complexity, to favor a rule whereby an agreement on a choice of law to govern the main contract should also apply to the arbitration agreement, even if a different country or national system of laws has been nominated as the seat of arbitration. But where parties do not make any express or implied choice as to the law that governs the main contract, the arbitration agreement is generally governed by law which is most closely connected with the arbitration, which is typically the law of the seat. The recent reform in Section 6A of the Arbitration Act 2025, inserting Section 6A into the Arbitration Act 1996, now conforms to the NYC's position that in case of absence of choice of law governing the arbitration agreement, the law of the seat will be applicable in case of UK. Next, there should be default clauses to deal with the situation where the parties seek to frustrate the arbitration. Generally, it is the respondent that sees that it has nothing to win and may have a lot to lose by participating in the proceedings that may lead to an award against it. Sometimes, in rare cases, a claimant may also seek to avoid arbitration in case of a substantial counterclaim. Now, the Article 30 Answer to All rules deals with such situation in detailed manner. Next is the language. The language of the arbitration. The customary and logical choice is that the language of the arbitration should be the language of the contract, which is the usual default position in institutional arbitration, but the arbitral tribunal has discretion to direct use of other languages as well. Section 20 of the ICC rules expressly provides, and I quote, in the absence of an agreement by the parties, the arbitral tribunal shall determine the language or languages of the arbitration, due regard being given to all relevant circumstances, including the law language of the contract. Then there are multi-tier clauses which are increasingly popular in international commercial contracts, especially long-term contracts such as construction contracts where parties seek to rapidly and quickly resolve disputes instead of holding up the work and losing out on precious time and resources that get locked up in case of protracted dispute resolution. So multi-tier clauses simply can have different structure to it. Generally, instead of going directly into a mandatory and binding arbitration that can be very costly and time consuming, it can involve parties to mandatory discussions, to talk to each other through their senior management, or have an early neutral evaluation by an expert appointed by the parties that may lead to a settlement in a quick manner. It may require mediation or an interim decision by a dispute resolution board or panel of experts, as seen in the Channel Tunnel contract between France and England recently. The key thing in regard to multi-tier clauses is the issue of enforceability. As it is a contractual term, it must be reasonably certain. In the Tang Chung case, the English High Court did not enforce a multi-tier clause on the ground that it was too equivocal and too nebulous, containing no guidance as to the quality or nature of the attempts to be made to resolve a dispute. Swiss court similarly in X case held that a multi-tier clause did not provide any procedural framework for negotiations, did not contain a time limit for the initiation of conciliation proceedings, and therefore was not sufficiently certain to be binding. The Australian approach is more liberal to it. In Australian case approach, any agreement to negotiate in good faith requires an undertaking to behave in a specific manner, and is therefore more than a mere agreement to agree. Singapore High Court held in a case that a bare agreement to mediate is valid and enforceable, referring to the conventional Asian value of promoting friendly negotiations and settlement whenever possible, taking a liberal approach compared to Swiss or English approach. Then there are sole option clauses. Under a sole option or unilateral option clause, one party has the choice as to whether to bring a claim in a specific forum other than the dispute resolution forum that binds the party or not to do so. English courts have consistently held that such clauses are valid and are therefore enforceable under English law. In Lord Debenture Trust case, the legal instruments contained that disputes would be resolved by English courts, but the bondholders would have the right to refer a claim to arbitration if they so wanted. The court said that it was not correct to argue that provisions of such a clause are somehow less even handed in any relevant way. They give an additional advantage to one party, but so do many contractual provisions, which may favor one party or the other. Therefore, it may be thought that when a clause in a contract is concerned with access to justice, whether that of a court or arbitral tribunal, it should not give an additional advantage to one party. Access to justice demands an equal level playing field. Nonetheless, courts have ruled that sole option clauses are valid and enforceable under domestic laws. For instance, in the case of France, a sole option clause is valid and enforceable as long as it either identifies an additional forum to which one party may refer the dispute, or the alternative, it provides for a criteria by which such forum can be objectively determined. In case of Russia, however, such clauses are held to be unenforceable based on not providing a level playing field and violating the principle of procedural equality between litigating parties. Finally, there should also be provisions for other procedural matters that will be elaborated later. With this contract,